YouTube, what's going on? Scump and Hex sued Activision. If you didn't know, I stream Warzone at nights, but I'm a practicing attorney during the day, so I thought let's jump right into the lawsuit and get you everything you need to know about what's going on. All right, so I'm going to break this video down into 3 parts. The first is Legal 101. What's a complaint? What's happened in the proceedings so far? What is going on? And then I'm going to walk right into the complaint and tell you exactly what Scump and Hex are alleging, what are the facts, and what are the claims that they need to prove in order to beat Activision in this monumental lawsuit. Now, of course, everything I'd say there is just Scump and Hex's allegations. These are not my allegations, and there is no legal advice being provided in this video. I'm just an observer trying to pass information to you. And then third, I'm going to offer you what's next. How does Activision proceed from here? How do Scump and Hex proceed from here? What's going to go on? And of course, I am going to be following these proceedings super closely and making videos to keep you up to date on what's happening. So if you want to like and subscribe to get those updates, please do. Let's jump right into it. Let's start with a little bit of Legal 101. To begin with, Scump and Hex did not draft this complaint themselves. They had lawyers, and these are their lawyers. Their information is on the complaint, as you're required to do. You have to sign as a counsel representing any party. When you file a complaint, you have to sign it and say who I am. And these lawyers appear to come from pretty sophisticated law firms who have good experience in antitrust litigation, which, as I'll talk about later, that's the subject of this complaint. So they're experienced lawyers. And by the way, this guy, Eric Rosen, was actually the lead criminal prosecutor on the Operation Varsity Blues case that we all heard about a few years ago, where parents were paying for their kids to get into Ivy League programs. They're like sending fake pictures of themselves rowing crew boats. And anyways, he has experience in big name cases, which is great. Scump and Hex have a good team behind them in suing Activision. And together, Scump and Hex have told their lawyers, here are the facts, here's what's going on. Their lawyers have drafted this complaint in close coordination with them, and they've filed this complaint with the court, and they've served Activision with a summons and said, you better get in here. It's time to litigate this thing. What's going to happen after the complaint? Well, I'll get into that at the end of the video. For now, let's jump right into it. The first thing I do when I check out a complaint is check out the claims. What violations of law are Scump and Hex alleging that Activision actually committed? And they have a bunch of claims, but all of them flow from one federal statute. It's called the Sherman Antitrust Act. It was enacted in 1890 by our federal Congress, and it was designed to break up big companies that were engaging in anti-competitive conduct. It's been used over the years against tobacco companies. It's been used against sugar companies. And most recently in 1990, the biggest sort of case that I can think of is it was used against Microsoft when Microsoft was inputting something in their computers that prohibited users from using other browsers. Basically, what the Sherman Antitrust Act prohibits is a company from amassing monopoly power in a specific market and then using that monopoly power to engage in anti-competitive conduct. Sometimes that anti-competitive conduct can be super clear, sometimes, which we call per se violations. Sometimes that anti-competitive conduct is not so clear. And in fact, over time, courts have had a really hard time figuring out what's actually anti-competitive conduct and what's just conduct that this company's this company is engaging in because their product is so good. If a bunch of consumers are just going to that company, we wouldn't call that anti-competitive. Anyways, what we're looking for in this complaint, because it's a complaint based on the Sherman Antitrust Act, what we're looking for is what we call monopoly stew. And monopoly stew is made up of a couple different vegetables and meats. And it says that if the company has monopoly power over some market, and then they start engaging in a variety of different types of anti-competitive conduct to keep out competitors, to keep out customers, to keep out users, then all of a sudden we might have a problem and the courts might step in. So let's see if Scump and Hex have alleged that perfect monopoly stew. It's hard to say whether a company has gained market power or monopoly power in a specific market if you don't first ask, well, what is the market that we're talking about? So that's what Scump and Hex have done in the very beginning of their complaint. They've tried to identify the market that we're talking about, and what we're talking about is Call of Duty tournaments. Seems kind of narrow, but it is a distinct market, and as Hex and Scump point out, Call of Duty players can't just, pick up the sticks and go jump and play a different game overnight. And for example, if you were required to do that, let's say we required Optic to just be a Dota team, for example, sure, Scump and Dashi might over time become good Dota players. Maybe they have to switch to the keys too. But that's going to cost a lot. And that's going to totally and dramatically change the nature of the product that they are trying to promote. So maybe they have good enough allegations to say that this Call of Duty tournaments is the market, and it's a relevant market, and it's the one that's going to define the rest of this litigation. So with the market defined, the next task for Scump and Hex is to be able to say that Activision, or at least allege plausibly, remember that's the task, allege plausibly, that Activision acquired monopoly power within that market of Call of Duty tournaments. So what do they say? Scump and Hex say that before 2016, there was a booming Call of Duty tournament league market. There was all sorts of different organizers. There was all sorts of different tournaments sponsored by different companies. But in 2016, Activision purchased basically the only and biggest tournament organizer, Major League Gaming, for $46 million. And thereafter, Scump and Hex say they have monopoly power. But just having monopoly power isn't enough. You have to allege that the monopolist actually engaged in anti-competitive conduct. And to their credit, Scump and Hex actually say that Activision purchased Major League Gaming in 2016, but then for a few years actually operated the Call of Duty tournament space in a pretty free way. They had qualifiers, they had an open league that different teams could come up through the ranks and work their way into final tournaments. This was the COD World League. They had sponsorships that could come from various non-Activision approved sponsors. They had team transfers. They had player transfers. They had all sorts of stuff between 2016 and 2019 that actually appeared as though Activision had a monopoly power but wasn't engaging in anti-competitive conduct. But in 2019, Scump and Hex say that things took a turn for the worse, or at least a turn for the anti-competitive. They say that Activision created the new league, which we now know as the CDL, or the Call of Duty League, and it's a totally different setup. You've only got 12 teams, you've got entry fees that are $27.5 million, and all sorts of different things that Scump and Hex describe as anti-competitive. But primarily, Scump and Hex say that Activision required their teams and players to sign two specific contracts that really generated all of the problems. So let's jump into those two contracts. The first agreement that Scump and Hex really identify as anti-competitive conduct is the agreement that they say Activision requires teams to sign before they can have a team in the Call of Duty League, or the CDL. And they say that that agreement is chock full of anti-competitive provisions. For example, they say that the team agreement has the $27.5 million fee, which no other team would pay in any open market that had an open league. They say that the team agreement requires each team to be backed by corporate sponsors who are approved by Activision. So you can't just be a super wealthy independent that Activision doesn't know and start a team. That wouldn't work, which actually over time created problems for Hex because he was just an independent guy who wanted to have his brand Optic back. And he says that created all sorts of problems for him. He had to go work with corporate sponsors that only Activision approved of. But the team agreement also has other provisions in there, like the teams can't promote other games. They can't have sponsors that are outside of Activision control, so they can't just go out and get their own sponsors. But the one that struck me the most was a revenue sharing provision that Scump and Hex identify. And it basically says that teams have to share half of their revenue with Activision and the other half with the rest of the league, meaning a team like Optic, who clearly creates way more content and better content, maybe FaZe is close, than most of the other teams in the league, they've got to share their revenues, and they can't really, benefit from the fruits of their labor and from their image and their likeness and things like that. And of course, the team agreements also have salary caps, but there's also a ton of other provisions. But that's the key agreement that Scump and Hex say is the one that causes all of these anti-competitive effects. Scump and Hex also point out that Activision requires players to sign a separate agreement, and they say that agreement also has anti-competitive effects. They say that it has things like the player's not allowed to stream other games. Basically, in some ways, it's not allowed. It doesn't allow the players to promote themselves to as big of an image as they otherwise would be. It allows Activision to use those players' image and likeness for basically no fee at all. There's an interesting provision in there that says basically Activision can follow them 24/7 in consideration for nothing. Activision just gets to, if you're playing in this league as a player, Activision basically gets to do whatever they want with your image and likeness at all times. And interestingly, in this section about the anti-competitive conduct Scump and Hex allege Activision to have engaged in, Scump and Hex point out that in a different case brought by the United States, the Department of Justice, A court has already found that, for example, the salary caps that the CDL imposes, that the Activision imposes through the CDL, are anti-competitive. So it's kind of interesting to see that these attorneys who represent Scump and Hex are building their case off of decisions that have specifically already been decided against Activision in other cases. So to say that all of this is coming out of total left field, I think kind of misses the mark. So again, Scump and Hex's first task was to define a relevant market, which they say is just Call of Duty tournaments, which might be too narrow, we'll see. The second thing was to say that Activision had monopoly power within that market. And they say, again, that in 2016, they purchased Major League Gaming and they got basically control over the entirety of Call of Duty tournaments. And then they had to allege that that Activision engaged in anti-competitive conduct, which they say flowed primarily from that team agreement and that player agreement. But finally, they have to allege that it injured them and that it injured the market. So they've got a ton of allegations about how Activision's conduct in the Call of Duty tournament space has resulted in injuries to Scump and Hex. For example, they say Scump couldn't make as much money as he would have made otherwise. He could have used his image better. He could have streamed other games better. He could have gotten a better salary, things like that. They also allege that Hex has been injured because, for example, now he has to be, in an organization that's backed by corporate sponsors. He doesn't get as much ownership of his organization, and he's suffered hundreds of millions of injuries, they say, in basically having to jump through all these hoops in order to just be able to put a Call of Duty team together and play in a competitive league. But they also have to allege injuries to the market more generally, and they do that too. They say things like, for example, Dota, another game that has big tournaments, has over time been able to use crowdsource prize pool systems in order to increase the amount of prize pools that competitors are able to get. Whereas compared to Call of Duty League, we can see that prize pools are just going down over time, they say. They also say that, sponsors are being hurt because maybe there's a sponsor that just wants to sponsor a team, but they can't really get into the whole Call of Duty League because Activision won't let them in. They say that in general, just all of the teams have been hurt in the similar ways that Scump and Hex have been hurt. So those are their injuries, and that's what they're claiming. This complaint has been filed in the Central District of California, which is a federal trial court. And what's next? Well, Activision has already responded outside of court on Twitter. They've basically said that this lawsuit is meritless, has no basis in fact in law. And it also appears, it alludes to the fact that there was maybe some pre-litigation negotiations that went south, and Scump and Hex just decided to file the lawsuit anyways. So what's next in the litigation? Well, Activision has two choices in general. They can first file a motion to dismiss, which basically says, just looking at this complaint, it is implausible that we violated any laws. So they may file that motion. Then, of course, Scump and Hex will have a chance to respond, and the court will decide whether the lawsuit can keep going forward. If Activision doesn't file a motion to dismiss, they'll file an answer, which basically says, we deny this, we deny this. You have three options in an answer. You can deny, you can admit, or you can say, I don't know, to each one of the allegations in the complaint. So Activision may file a motion to dismiss or an answer. And then, assuming that the lawsuit goes forward, it's on to litigation. There's going to be discovery, where each party exchanges information, but we're not going to get into all that. That's going to be future videos as we learn more. In any event, if you like this content, make sure to like and follow, as I'll be tracking this case super closely, and I'm also live on Twitch every night. See you there.